206, People versus Soto. Counsel, you want your rebuttal time?
Yes. Can I request 2 minutes, Your Honor?
2 minutes. Go ahead.
Good afternoon, Your Honors. May it please the Court, Melanie Sarver for the Bronx District Attorney's Office. Absent some indication that the declarant was fully and contemporaneously aware of her exposure to criminal life.
She was talking about being in trouble and, what's going to happen and what more do you want?
There were two problems with respect to the awareness factor of the elements of a declaration against penal interest.
Parents knowing what does that signify to you?
The declarant went through her entire colloquy about what happened on the night in question before expressing any concern regarding either parental disappointment or a very vague general concern about, could I get in trouble for this? And so that goes to two problems with respect to awareness.
The first, she raised it in the same conversation, whether it's not clear, I don't think, from the record, whether it was before the written statement or simultaneously with that. But if she blurts this out at that time when she's being asked to sign this thing, or and she realizes this is really serious, how can we not infer that those same concerns were going on in her head 2 minutes before that when she was talking about it? And why aren't the same indicia of reliability present in that circumstance?
The record actually is quite clear, and the majority decision in the appellate division actually acknowledged that she did not express any concerns, whatever they may be, until after she had gone through the whole conversation with the investigator. While admittedly, I don't recall, and I'm not sure if the record reflects how long that conversation was. It does appear that she sat down in the investigator's office, and it hadn't occurred to her that she could get into any kind of trouble for what she was about to do. It almost seemed as if...
How is that? How is that? He's under criminal prosecution, and now she's going to say she's the driver? How is that?
She's a 19-year-old with only a learner's permit. I don't even believe...
And why doesn't that make it even more likely that this concern is front and center? Because
she had absolutely no experience with the criminal justice system.
She's totally just devoid of having a mind at 19 years old who has a learner's permit. None of this, and as Judge Stein indicates in the same conversation, she's talking about this. How do you read all that away? Because she's 19 years old?
She certainly had a mind at 19 years old, but perhaps her concern was preoccupied with what her parents would think about the whole incident.
But then why did she keep asking about whether she needed a lawyer? How can that be? I mean, certainly if her parents were upset with her, she wouldn't need a lawyer.
That could have come into play, two points in response. First, that could have come into play later on in the conversation with the investigator. And it's our position that that is not a contemporaneous awareness of exposure to criminal liability, because at the time that she was actually uttering the words and putting forth the statements, it was not necessarily going through her head that she could need a lawyer.
Contemporaneous with her being asked to sign a statement.
But that doesn't go to the reliability of the words that she actually uttered at the time that she...
Why not? Because if she said something that, wasn't exactly true, but now she's being asked to sign as to those words, doesn't that solve the problem?
Your Honor, for all we know, she could have been asking for a lawyer in case she was concerned that she was signing her name to a lie, and she might have been interested in...
But you don't have to prove it here. You just have to show some sense of awareness. It seems, there isn't much case law on this particular hearsay exception, but it seems that you're saying that a person has to be aware of the legal ramifications of their statement before they make it, rather than be aware that it could cause some problems for them, some legal trouble. But they have to know almost the penalty. It seems you're setting a bar that's unreasonable for a layperson to meet.
They don't have to know the specific crime or the specific statute. There's no requirement. Though the trial court did...
Tell me this. Point me to a case that says, that articulates your standard.
Says when the statement was made, the declarant must be aware that it was adverse to penal interest. And
so
here,
what if she becomes aware while she's talking?
If she had backtracked or changed her statement or refused to sign without talking to a lawyer, all of those would have indicated some awareness or development of an awareness to adversity to her penal interest.
Could also indicate that she wanted to help them, and that even though she was aware that it might cause problems with their parents, she might need a lawyer, she was doing the right thing in her mind.
Well, to me, if she refused to sign, that would indicate that she wasn't telling the truth.
Or it could acknowledge that she felt that she needed to talk to a lawyer to understand her penal interest because, as the trial court admitted, this was Vehicle and Traffic Law 601A was not necessarily a common crime to be aware of.
Aren't you reading too much into her mind? You're just writing off half the things that she said because by fiat, you're making the contention that she didn't really mean it. She's really not aware of it. Again, is it only because of her age? In other words, you're just writing off half the things that she said.
Absolutely not, Your Honor, but that just goes to show.
What do you mean absolutely not? You are.
I don't mean to be writing off what she's saying.
What are you doing with what she said?
Just pointing out the need for cross-examination of this witness. This is an unreliable statement without an opportunity to cross-examine the witness as to her frame of mind at the time of the conversation with the investigator, in addition to her frame of mind at the time that she was confronted by the defendant on the bus approximately 2 weeks after the crime.
Why wasn't she questioned?
Why wasn't she questioned?
Yeah, I mean, I get the statement against penal interest being, you know, with a big fight over immunity or something, but why couldn't you put her on the stand and ask her what she said and what was said? And I thought everything that Amelcan said was hearsay. I didn't know why that was even getting in the record. She's saying this witness is saying, well, that's hearsay, and it's going to the truth of the matter stated. It shouldn't have gotten in, and yet everyone's talking about, well, she said this, she said that. I get the point where she, you know, if she's going to say I was driving, and that may be a statement against penal interest, but everything else isn't, and she could have gotten on the stand and talked about coming to the office and realizing that maybe she was putting herself in jeopardy, but nevertheless, you know, felt that she had to tell the truth, whatever it was, and none of that happened.
Your Honor, my understanding is that she pled the Fifth because she didn't want to incriminate herself.
Understand my question?
I understand why she didn't. I understand you're asking why she didn't testify up until the point of saying she was driving. Your Honor, I honestly don't know the answer to that question. However, the whole case rises and falls on the fact that there was no reliability and no trustworthiness in her statement, and she needed to be cross-examined by the people in order to put before the jury fair evidence that they could understand the veracity and reliability of, and especially in a case like this where it appears that her motive, whether it was true or not, in coming forward was to help out the defendant. The jury was certainly entitled to understand exactly what was going through her mind at every point in the process, including her conversation with the investigator.
What motive is there for her to lie under the circumstances of this case? We were talking about reliability. What possible motive would she have had? She only knew this guy for a few hours, as far as the record shows.
I'm not personally familiar with the witness or her relationship with this gentleman, with the defendant.
I'm talking about what's in the record. What's in the record is she met him on a bus a few hours before she then went out with him, and then she didn't see him again until she ran into him 2 weeks later on a bus, I guess, and he asked her to help him. Why would she have a motive to help him?
If she liked him, if she felt pressured by him, if she felt threatened that he was going to keep harassing her if she didn't come forward, if she was trying to impress him. There are a number of reasons that she could have decided 2 weeks later to reinsert herself into this investigation.
And under your argument, and she didn't think anything would happen to her if she did help him.
She was not aware of any
because
consequences.
Otherwise, why would you do this, even if you're interested in it, right?
Her jeopardy, if there was any, was not what his was. He was facing DWI. There was never any claim that she was drinking and driving.
She would have only been facing leaving the scene of an incident without reporting and potentially driving without a license, though if he was a licensed driver in the car with her, that might have been.
Okay, good. Thanks, counsel. You have your rebuttal.
Good afternoon. Mark Zeno for Respondent Victor Soto.
Counsel, how do we know that that she was aware of that this was a declaration against interest?
Well, I think there are a number of facts from which the appellate division appropriately drew the inference.
Well, your adversary says she said it later on in the conversation, so doesn't really matter.
Well, I would start with the accident itself, Your Honor. She fled the scene because she was worried she was going to get into trouble. If a driver, whether it's a 19-year-old driver or a 54-year-old driver, crashes a car and runs away, they're running away because they fear the consequences of the action, whether it's property damage, whether they're worried they violated a traffic law. They're fearing the consequences of that crash. So that's
the
the
argument
starting.
that defense made?
Did they make that particular argument? I don't think they made that particular argument. So that's the starting point.
Well, what's the declaration against penal interest that is being asserted?
The declaration against penal interest that's being asserted is that she was the driver of the car. She crashed the
That's
car.
allowed. She had a learner's permit. She could drive.
I'm not saying she was driving unlawfully. She may have been.
Well, I'm looking for the penal interest that.
The penal
that
interest
she
was leaving the
testifying.
scene. And it's not only a penal interest, it's a pecuniary interest.
Was that argued? I didn't see it. That's what
Well,
I'm
the
asking.
court did refer to it. I believe it was at page 248 of the appendix. The court said it's not only a penal interest, it's a pecuniary interest. I think that was the court's word. So
Does it matter if she's aware that, in fact, it was adverse to her interests as opposed to, well, she wasn't really sure, but maybe, and she was concerned about it? Is there a distinction there in terms of whether this statement should be admissible?
Well, I think it should be admissible under either circumstance. I think the question is it a statement, given the magnitude of the interest that's involved, that a reasonable person would make, unless it was true?
So you agree she has to be aware of it?
She has to be aware that it's an adverse interest.
That it's penal,
Yes.
against penal interest, right? Isn't
No,
it?
not against penal interest, Judge. It's this Court's declaration against interest exception started with proprietary interest.
Broader.
And I think it was in Brown, the Court talked about an interest in an Elgin watch, which is an inexpensive watch. And if an
Used to be.
It used to be. Maybe it's worth more now. But if an interest in an inexpensive, mass-produced watch is enough to trigger the declaration against penal interest, declaration against interest exception, that should be enough.
One of the things that troubled me about this is that we talked about, she said, should I get a lawyer? And this investigator said, I have no idea.
Mm-hmm.
She asked whether or not she could get in trouble. I had no idea. When she was cross-examined about any of these, she said, I don't know. And this is an investigator for a criminal defense firm. And here's this lady coming in and saying what she's saying. And as the court said, he said, I just don't see it. I don't see the awareness of any penal liability.
Well, again, doesn't have to be awareness of penal liability. I think there were three.
Liability.
I think there are three reasons she was worried about making this statement. One was she was worried she was get in trouble with her parents. That's obviously a
Does it trouble you at all, though, what the defense did here to this lady? I mean, if she asked for a lawyer and they didn't give her one, when she asked, whether or not she could get in trouble and they blow her off?
Well, if it
I'm
were
being cruel in saying blow it off.
If
but
it were a lawyer.
let me say this. It was disturbing to me that they almost were taking advantage of this young lady. I mean, maybe she really was in trouble, and maybe she should have had a lawyer, and maybe somebody should have told her that, and maybe she wouldn't have talked at all. Or maybe she should have said, I understand all of that, but I'm telling you, this guy wasn't driving, I was. And then you'd have a much clearer record. I just thought that the defense here was a little rough with this lady.
Well, it wasn't a lawyer. It was a recent college graduate, I think the record shows. And
You're talking about the investigator.
The investigator.
Oh.
And the investigator's interest was in exonerating her client with credible testimony, credible information. It was her plan. It was the defense's plan to call this young woman as a
But that's the
witness.
point of awareness. In other words, if I'm exaggerating now, I don't want anybody, if they say, well, look at it, we haven't told her the truth about this, she's never going to talk. So let's tell her, that you've got no liability here.
Well, that's not.
Wait a minute. I want you to agree with me eventually. There is no, you've got no liability here, and you're going to help this guy out. He's going to lose his job as a bus driver. If he gets convicted of this. So it's really, really important that you say you were driving and you have no worries whatsoever. That would be improper, wouldn't it?
Well, that would be improper. That's not this case. There was no evidence, there's no testimony in this record that the investigator discouraged
So what was the tenor of
her.
this conversation?
I'm sorry?
What was the tenor of this what was the investigator trying to do? What was she trying to say?
Well, the
You know what I'm saying?
investigator.
What was the ambiance of all of this?
The ambiance, well, it was in a lawyer's office, so it's probably not somewhere that 19-year-old had been before, so there was a certain level of seriousness to the conversation, but it was only a conversation with an investigator who asked her to tell the truth. And the woman knew that my client had been arrested and was facing charges.
How do you interpret her comments?
How do I interpret
Trouble, the parents, all that stuff.
She was concerned about making a statement. She was worried
What
about
did the
getting.
investigator, in the face of that, how did the investigator make her feel?
I think that the investigator put her off, didn't really respond directly to those concerns.
Didn't want to answer her either
Yeah,
way.
neither told her that you have nothing to worry about, nor told her that you absolutely should go out and get a lawyer. She didn't want to give legal
Is that
advice.
for fear she'd clam up?
I'm sorry?
Is that for fear she'd clam up and stop talking?
I think that's probably true, yeah. But I don't think that makes her statement any less credible. The appellate division drew an inference from this record that she knew that the declaration was against her interest.
On cross-examination, she said that she was also concerned about the trouble she could get into. Answer, yes. Then at this point, you told her, you're not a lawyer, you can't really tell her about what's going on. Yes. You didn't tell her the charges that she might face? No, I don't know those. Like the VTL 600, you didn't mention that? I don't know what that is. Or driving without a license? No. You didn't tell her that she faces civil investigations? I wasn't aware of that. No. She didn't tell you anything about specific trouble she might get into? I did not know. When she told you that, I mean, you couldn't know that? No. And it's no. And it's not until
she didn't want to give that. The investigator didn't want to, was forbidden from giving legal advice.
I understand that. But what I'm saying is that you want to say this lady was concerned about getting in trouble, and you're saying, what, it was the investigator's job to make sure she didn't think that.
She was asking, should she get a lawyer, and that's adequate to show she was concerned that she might get in trouble. It's also common sense. Everyone knows that fleeing the scene of an accident, every driver knows that fleeing the scene of an accident is an offense, whether you know it's punishable as a VTL violation, a misdemeanor.
Didn't know.
Right. I didn't know that it was a 15.
So your
I didn't
view-
know it was a
your
15-day penalty. I knew it's a crime. I knew it was wrong.
Your view, in response to what Judge Piggott was asking you before, as long as the investigator didn't falsely put her in a place and say, listen, don't worry about it, there's absolutely nothing that's going to come of this, as long as the investigator was kind of not trying to pull her in either direction.
Right. And
That's appropriate, and that, I'm just trying to understand your argument, and that on its face, what she's saying evidences enough of an awareness to be a statement against.
right, exactly. And if the investigator had said that, you have nothing to worry about, there's no crime here, just tell me what I want to hear, then that, that knowledge of adversity would go away, and
If
there'd
the
be no.
people did this, would you think it was okay?
If the people did this, I think the people do this all the time. I think that's what
cynical man.
detectives
Very
are.
cynical
Well,
man.
having done this job as long as I have, you can get cynical about things like that.
You think
I
it's okay?
Do I think it's okay?
Oh, you're saying that people do this all the time and it's okay?
Well, I'm not sure what this is.
Well, that's what I asked you. If they did this,
If they
if
did
if they brought this young lady in and said, look, you got no problems, don't worry, it's all fine, look, we're just.
Well, I think that the people have a higher burden than a defense
But you're arguing
investigator.
the investigator didn't do that.
Right. Right. I mean, I don't think that would it be appropriate for a police officer to lie to a defendant to get a statement, tell him, admit to this murder, you can go home tomorrow. That's wrong. That's not what happened here.
Well, we've had cases along those lines. Yes.
That's what I was referring to, Your Honor.
Okay, counsel.
Thank you.
Thanks. Counselor, rebuttal.
Counsel, what's our standard of review? What are we looking for here?
We're evaluating a question of pure law.
It's not a mixed question of law and fact?
No.
Why not?
The facts are undisputed. Even the majority in the appellate division acknowledged that up until the point where the witness was asked to put her pen to the paper, there was absolutely no recognition or.
Isn't the question the inference is to be drawn from the totality of the circumstances?
Excuse me?
Isn't the question the inferences that can be drawn and whether or not that now spins back to a mixed question of law and fact?
The question is to define awareness and how broadly to construe
Isn't there
awareness.
some record support for what the appellate division found? And if there is there really any issue here?
The issue is whether what the appellate division found in terms of the facts is sufficient for a definition of awareness that this Court would set today. And our position is that when a witness does not recognize or acknowledge or understand anything about consequences that she's facing until after making a whole statement, that's not sufficient for awareness. And with exculpatory statements, while there is leniency accorded to a statement in terms of the fourth factor, the corroborating independent evidence, no leniency applies to the awareness factor. And so a definition of awareness must be set that appropriately construes all of the facts. And here, her frame of mind at the time of
so your argument's totally a matter of law.
completely a matter of law.
Okay. Thank you.
Thank you.
Thank you both.